So we'll go ahead and get started today. We have a lot of fantastic content to cover. My name is Lisa Rice, and I'm the Chief Sales Officer here at Sanderson Firm, and I'll be the moderator today. We appreciate everybody taking the time to join us on this important topic that we'll be covering Medicare set-asides in 2024, trends, updates, and predictions. Just a few housekeeping items. The slide deck and the recording for today's training will be provided to everyone on the webinar. If you have questions during the webinar, please put them in the chat function. And once we get to the end of the webinar, we will answer those questions. If you do ask questions anonymously and we can't get to your question, please feel free to reach out to me directly and we'll ensure that your question gets answered. There'll also be a survey that comes out, and we value all your feedback on those surveys. So we would really appreciate you filling those out. Also, if you have any issues during the webinar, please add that in the chat function and we'll work to see if we can help you get that resolved. For those of you that may not be aware, Sanderson Firm is a proud woman-owned business solely focused on all aspects of Medicare secondary payer compliance, from Section 111 reporting, conditional payment, lien resolution, MSAs and alternatives to MSAs, as well as settlement release review and Medicare legal guidance. Our team is comprised of legal, clinical, and claims professionals with over 200 years of combined experience in the Medicare secondary payer space. If you have any questions or would like some information about Sanderson Firm, please feel to reach out to us. I'll go ahead and introduce our awesome speakers today. We have Heather Sanderson, who is the founder and CEO of Sanderson Firm. Heather's one of the foremost nationally recognized experts in Medicare secondary payer. For more than 15 years, Heather has devoted to providing simple and straightforward MSP compliance solutions, including legal guidance, support strategies, as well as Medicare secondary payer education to the insurance community. Joining Heather is our managing attorney, Brendan D'Souza. Brendan manages our legal department and joined Sanderson Firm in 2021 after previously serving as in-house compliance counsel for one of the nation's largest Medicare secondary payer compliance services company. Last but not least, we have Deanna Lawrence, who is our Assistant Vice President of Clinical Services. Deanna is a licensed nurse and a Medicare set-aside certified consultant, and she oversees our clinical department. She has over 20 years experience in the work comp industry. So I will turn things over to our speakers.
Great. Thank you so much, Lisa. And hello to everyone on the webinar. Happy New Year. Happy 2024. We have a lot to discuss, and we're going to dive in right away because we want to make sure to hopefully get to some of your questions. I know that you have them. Please feel free to type those into the Q&A chat function in Zoom. We'd be happy to get to those. So first, we're going to talk about MSAs generally and just sort of set the stage, especially for those of you that might not be so familiar with Medicare set-asides. We're going to talk about one of my favorite topics, the non-submit and submit dilemma and the pros and cons of both. We're going to also talk about the non-submit language that caused sort of a commotion with non-submit MSAs in 2022. We'll talk about what's going on with that about 2 years later and where non-submit MSAs stand today. So that will be an interesting one to update you all on 2 years post reference guide update on non-submit MSAs. Just the end of last year, we learned that potentially the Centers for Medicare and Medicaid Services may be requiring that work comp payers report Medicare set-asides in their Section 111 data to CMS. We'll talk about that, and we're going to go through the proposed timelines. And again, there's nothing set in stone there, but it's interesting and something to watch, so we'll let you know what's going on there. We're going to talk about the current contractor that's currently sitting at CMS. This is the Workers' Compensation Review Contractor, also known as the WCRC. It's the private entity that reviews proposed MSA submissions and what's going on there. And then we have a really great guest speaker today, Deanna Lawrence, who is in the heart of our Medicare set-asides on a day-to-day basis, making sure our clients have the most defensible, cost-effective, and reasonable Medicare set aside. She's going to be a wealth of knowledge on some cost containment strategies today, providing you with what she sees, and hopefully you can take away some best practices with your MSAs back to your organization. And last but not least, $0 MSAs and what's going on there. So for those of you that are not familiar with what Medicare set-asides are, it's an allocated portion of an injured worker's settlement, which is allocated toward their future medical care. This is a part of settlement strategy, right? Obviously to resolve the Medicare beneficiary's future medical, and the intent behind Medicare set-asides as introduced by CMS since 2001 is certainly to protect the Medicare trust fund from paying for future treatment that the injury otherwise would cover, right? So it is present in both workers' compensation and liability claims, although of course, we have far more guidance around work comp MSAs than liability MSAs from CMS, but notwithstanding, they are a fixture in both when you're looking to settle out a Medicare beneficiary or a reasonably expected Medicare beneficiary's case, and they might require future medical as a result of the injury. So very important. But the intent, again, behind Medicare set-asides is so that Medicare does not pay for injury-related treatment in the future. Of course, the injured worker is still going to have their Medicare benefits for their unrelated, non-injury related treatment, but of course the MSA should only be paying for that injury-related treatment in the future. And as a general rule of thumb, an MSA is appropriate in a settlement where future medicals are being released, the individual will require future medical care related to the claim, and the person is currently a beneficiary or has a reasonable expectation of becoming one within 30 months of the settlement date. Now, really important to note that CMS's workload review thresholds are irrelevant for determining whether it is appropriate to fund an MSA. Brendan, I'm sure that you get questions about this on a day-to-day basis. Well, my settlement is under $25,000. I don't need an MSA, right? What do you say to that when you hear that from clients?
Yeah, so as you said, super common question. People think that in the industry that if you're dealing with either a Medicare beneficiary or a reasonable expectation claimant and it doesn't meet submission thresholds, then because it doesn't meet submission thresholds, then somehow you don't need an MSA at all. So yeah, I point them to the CMS guidance. In the WCMSA reference guide, there's actually specific examples that says, look, if you don't prepare an MSA in this scenario, then the entire settlement amount is at risk for being used for that claimant's future medical care covered benefits. So the great debate. So non-submit MSAs versus submit MSAs. So mostly everyone I'm sure on this webinar, I'm sure is familiar with the concept of just traditional MSAs. So you're dealing with an individual who's a Medicare beneficiary or a reasonable expectation claimant, and the claim settles, you have an MSA, and because that allocation meets CMS submission standards, that allocation is submitted to CMS. That's one sort of universe of MSAs. On the other hand, some of you may not be familiar with or too familiar with non-submit MSAs. So non-submit MSAs are, simply allocations that are not submitted to CMS for review and approval. So with non-submits, an allocation can be a non-submit for any number of reasons, either because one, that claim doesn't meet CMS's submission thresholds. Therefore, even if the parties wanted to submit that allocation to CMS, it just can't be submitted. Or maybe in, I guess, rare cases, maybe that allocation actually was submitted to CMS, but let's say CMS issued a development letter and CMS is asking for certain medical records, and maybe it's difficult or impossible to get those medical records. The parties decide, okay, hey, look, we tried to submit this allocation to CMS. It's just not working. So we're just going to withdraw this allocation and just go the non-submit route. Just fund the allocation without getting Medicare's sort of determination letter on the file. Then you have other scenarios, which is probably the most common. We see this all the time where clients come to us, they say, look, we know we're dealing with someone who meets submission status, but we just don't want to go through the submission route with the government, right? So that's obviously the major distinction between the non-submit MSA and the MSA is just the non-submit MSA is not submitted. But also the major distinction is typically non-SMIT MSAs are prepared using evidence-based medicine. So whether that's state guidelines or whether that's national guidelines such as ODG or ACOM, evidence-based principles are applied to prepare the MSA, which typically results in a more reasonable allocation over the life of the claimant. And CMS's own policy guidance actually supports this, right? So in the WCMSA reference guide, Medicare states, quote, "It references evidence-based guidelines as resources in determining future treatment," right? So here you have Medicare themselves in its own guidance, signing off on using evidence-based principles in these MSAs. So it's fully defensible and supportable per CMS's own written guidance. So what we've seen over time, and this is actually borne out in some stats here on a later slide, but we've seen non-submits have just really increased popularity over time for a number of reasons. One being CMS submission turnaround times. Thankfully, gone are the days where you would submit an allocation to CMS and it would take CMS 6 months or longer to issue a determination on that file. Right now, we're looking at a couple weeks, maybe a month for CMS to get a determination out on a file, assuming it's just smooth and no issues. But sometimes, for a carrier may find themselves in a scenario where, let's say they just made a super slam dunk attractive settlement offer, and they think, look, if we submit this allocation to CMS and it's going to take CMS a couple of weeks or a month to approve this thing, maybe in that time the claimant is going to back out, and they just want to settle the claim as fast as possible, right? And so in that scenario, submitting an allocation to CMS just looks less attractive. Also, if you submit to CMS, there's limited appeal options. And I know there's probably a small subset of you on the webinar here who heard the word appeal, and probably that kind of sounded like chalkboard, because obviously, so there's the amended review and the re-review process. Those are not formal appeal options. CMS does not reference them as appeal options, but I'm using the word appeal broadly to sort of get people to understand what I'm saying, right? That is, you submit an allocation to CMS and you disagree with the allocation, you think CMS's determination on the MSA was too high, so you want to appeal that decision with CMS and request that CMS re-review that to get that amount lower. So those two options, the amended review and the re-review, you can't request those in every single file. There are certain criteria that have to be met. So if you're a party who submits an allocation to CMS and you don't meet those criteria, well, then you're kind of stuck with that allocation without any real recourse. And then lastly, too, we've seen some interesting counter-hire statistics. I'm actually going to save this for a later slide where we actually give some stats, but we've seen some interesting stats from CMS published just about a month ago. So some advantages of the non-submit MSA or evidence-based MSA. So generally speaking, it results in cost savings. Not always, but generally it does. We see this a lot when opioids are involved. Just opioids are very expensive medication. So what happens if you prepare an allocation with an individual who's injured, taking opioids, and let's say they're on a very heavy opioid regimen for 6 to 12 months prior to that Medicare set aside being submitted to CMS. Well, CMS is going to pretty consistently allocate those specific drugs or that drug over the full life expectancy of the claimant at the same dosage and frequency without any consideration of weaning whatsoever, right? So CMS essentially imposes a snapshot approach. And so if this person has this specific treatment recently before the MSA is submitted, CMS is going to assume they're going to need that exact same treatment for the rest of their life, which is a little bit unfortunate. It makes sense from CMS's perspective, right? The Medicare trust fund, right, doesn't have an unlimited bankroll. And if Medicare were not to assume a worst case scenario that someone would need lots of opioid treatment, that would deplete the fund, and essentially the employer and the carrier would have that burden shifted off them, right? So by Medicare sort of assuming worst case scenario and requiring the employer and the carrier to fund these treatments in the allocation, it preserves the Medicare trust fund. And then lastly, too, we see that if you go the non-submit route, This does bypass some of CMS's pretty strict requirements. As an example, CMS will recognize state-specific statutes addressing the limits of future medical treatment. We see this in states like Georgia and Maine. However, submission of the MSA requires a court order approving the application of the state statute. So if you submit an allocation to CMS and you provide CMS with a copy of the state statute, sort of explaining why the treatment should be lowered per the state statute, Medicare is actually going to require you to provide them with a court order signed by a judge where the judge says, yes, look, this state statute applies, less treatment is legally appropriate. Without that, CMS is going to either A, issue a development letter, or B, just assume that state statute doesn't apply. They're going to allocate the full treatment of the MSA for the full life expectancy of that claimant.
And if I could add, Brendan, there's alternative C, which we've seen, right? Like, for example, with Georgia, Georgia has a law that limits employers' responsibility for future medical treatment on non-catastrophic claims to a period of 400 weeks, right? So theoretically, in that scenario, so long as the employer or insurance carrier has this court order saying that the employer carrier meets the requirements of a non-catastrophic claim under Georgia work comp law, so long as you submit this court order along with your proposed MSA to CMS, then theoretically, Medicare will limit the treatment to 400 weeks rather than lifetime. But we've seen specific examples where you've done all of that, right? Submitted the court order, done everything that Medicare has asked, but yet the reviewers at the WCRC, unfortunately, can be inconsistent. And we've seen some egregious file reviews, unfortunately, on some MSAs where the WCRC reviewer disregarded the court order entirely. In fact, I was personally involved, it was last year or the year before, on one of these cases where the reviewer at CMS actually decided that the claim was catastrophic. They were, an expert in Georgia work comp law on this particular day, and disregarded the court order and counterhied the MSA well over $1 million. And it was something where we had to step in. This wasn't our MSA submission, it was another vendor's. We actually got involved in fixing it and telling Medicare they needed to follow that court order and got that retracted. So just be wary, when you've got an issue of state law and you're submitting an MSA to CMS, just know that it can be tricky. Medicare sometimes tries to step into the place of actually being the determinant of your responsibility under state law, which is inappropriate. Medicare should be respecting the state law and then determining what goes in the MSA only within the confines of that state law and what you're responsible for. So something certainly to be cautious about. And we're going to also talk about how that interplays with zero MSAs later on in the presentation as well.
Okay, so I alluded to earlier the example of CMS assuming worst case scenario. Now we can dig into some specific examples of this and like how this actually would play out in a real life claim. So, let's say you want CMS submission, you have an allocation, and let's say the injured party has not returned for treatment in several years. So this happens a decent amount, actually. I'll get calls all the time. Say, hey, Brendan, I'm looking at this person who is a Medicare beneficiary and they last treated in 2016, but we don't have any records and we don't think they're treating, so they must be all healed. So if we get an allocation on this, we can just simply prepare a $0 allocation and Medicare is going to sign off on this, correct? No, that is not correct. Just because you don't have, most up-to-date current records, Medicare is not going to assume that that means that this person has fully healed, especially in a case where, let's say this person was treating pretty heavily before they sort of, quote unquote, fell off the face of the earth. But just because these bills and these records are not being submitted to the carrier doesn't mean that this person actually did stop treating. So if you find yourself in a scenario where, there's an lack of medical records and you think that this person hasn't treated in some years, it would be appropriate, and CMS is going to require that you have that person go to their treating physician, have the treating physician issue a letter, one, confirming the date of last treatment, and also confirming in writing that, yes, this person has fully healed, and no, they will not require any further claim-related Medicare covered treatment. Without that, Medicare is not going to assume that this person fully healed. So we see that a lot. Another scenario is when surgery is recommended, but the injured claimant is not medically cleared for surgery. Well, in this case, Medicare is going to assume, sure, the person is not cleared for surgery right now, but maybe they are medically cleared or will be medically cleared in the future, right? So Medicare would include the cost of the surgery in the allocation, and that would of course drive up the cost of the allocation, and that cost would be shifted on the employer and carrier to fund through the actual MSA itself. We also see this when surgery doesn't even have to be recommended. It could simply be noted or mentioned in the underlying medical records. And the physician, again, as you see here, the physician does not make any firm recommendations. Just a simple mention or just note of surgery in the records is enough to raise a flag with CMS, and it would not be surprising for us to see CMS include the cost of that surgery in the allocation itself. And then lastly, if a state statute is provided to confirm that reduced medical care is appropriate, but a court order confirming the application of the statute is not provided, then look, Medicare may just simply assume that the statute doesn't apply, right? And Medicare will say, look, carrier, you're responsible for the full amount of this for this MSA without any reduction at all. Okay, so statistics. So I believe at the end of last year, and I believe the year before last year, I think CMS has only done this twice, if I remember correctly, but CMS actually released statistics for MSAs that were submitted to them for the entire year. CMS did this last year, CMS did this year, and they released stats dating all the way back to 2020. I personally love this. I love the transparency. I hope CMS continues to do this each year because there's a lot of information to be learned from this. So what did we learn from the stats that were submitted or published last year? So one, the average amount or average submitted Medicare set-aside amount submitted to CMS last year was $71,000. On average, CMS's approval amount was about $86,000. So we see here that if CMS is going to issue a counter higher on the file or disagrees with the parties and thinks that the allocation amount should be higher, it's going to generally result in a 22% increase. So if you're an organization who maybe doesn't submit too many allocations to Medicare in a year, maybe that's just a nominal figure, but I mean, you can see pretty quickly here, 22% across MSAs, that can quickly rack up to the hundreds of thousands, potentially millions of dollars, right? So that's a pretty significant stat that we saw. Other super interesting things. So and by the way, CMS only released stats dating back to 2020. I wish we had the 2019 and previous stats. We don't, but regardless, in 2020, there were 16,500 MSAs submitted. We saw that number go down in 2021 to 14,800 MSAs submitted. We again saw that number go down in 2022, 13,700 MSAs submitted. Last year, surprisingly, we saw an increase, not quite up to, not quite up to 2020 levels, but more than 2021 levels, which personally I found pretty interesting. I was personally just you see the trend. I was just going to assume that that trend would increase and carriers would continue not to submit MSAs to CMS, but for whatever reason, that amount actually increased. Curious to see what happens this year and moving forward for 2024, 2025. We think on this end, I mean, maybe it's because more claims as we move out further from COVID, more claims are settling, and just because the volume of claims has increased, maybe just more MSAs are being submitted to CMS. But also last year, if some of you remember, Medicare actually removed its 72-month cap on amended reviews. So prior to last year, if you had an allocation submitted to CMS and CMS issued a determination, if you waited longer than 72 months to appeal that decision, you were kind of out of luck. You were forever barred from the amended review process. So not anymore, right? Now you can have an MSA that's 20 years old, however many years old. You can actually submit that allocation to CMS. So maybe that could be a reason why we saw a specific rebound or increase last year.
Brendan, just quickly, can you share our story why we think that Medicare removed their cap on amended reviews?
Yeah, so we had a client. I'm not gonna name the client, but we had a client who came to us. It was a particularly egregious claim. I can't remember the specific facts, but just looking at the file, you could tell that this client had a CMS determination that was, I think it was 8 years old at the time. So it was past the time frame from amended review. So this client had the option of either one, funding this really ballooned MSA amount that didn't make sense in light of the claimant's current treatment, or they could simply just really not settle out future medicals and continue to pay the claim forever. So the client came to us with this problem. We said, look, we told them like this is what CMS guidance is. Sorry, we can't do amended review. They said, look, we don't care. What's the worst that could happen? CMS is just going to say no. So we said, okay, sure, that's great. We loved it. So we challenged CMS. We reached out, made the request, and CMS said they were going to allow a one-time exception. CMS acknowledged, look, it's past time frame, but look, one time we'll take this file, we'll take another look at it for you. Not more than, it was like 2 weeks later that CMS updated the actual reference guide itself, and they completely eliminated the 72 month cap. So coincidence? I don't know. I don't know. So, but just a feel good story for us.
It is a feel good story. I'm glad we gave them that nudge because, it really was inherently unfair that if you had an MSA determination over 6 years, you were just, stuck with it. And to that end, what we had said to Medicare was this MSA no longer reflects the current medical treatment that this claimant needs. And we got the MSA to go down significantly by having it on an amended review. So really, yes, definitely a feel good moment from 2023. Some not feel good moments. I remember the day that this reference guide section came out in January of 2022. This new section 4.3 that Medicare added to their work comp MSA reference guide that seemed to be a direct attack on non-submit MSAs. And there's a lot of language here on the screen, but essentially what it says, this initial language, and again, it changes later and I'll cover that in a moment, is that Medicare was not going to acknowledge any non-submit MSAs and we're going to deny Medicare beneficiaries coverage up to their whole settlement amount, regardless of the fact that there might have been a non-submit MSA. They were going to automatically deem non-submit MSAs to be a burden shift. It was certainly out of line. It is out of line with actually the regulations that they cite here, because 42 CFR 411.46 D2 actually allows for non-submits and allows for parties to carve out a portion of the settlement for future medical, and CMS submission is not a requirement. I mean, Medicare's reference guide, the WCMSA reference guide, says in multiple spots that CMS submission of an MSA is always voluntary. There is no statutory or regulatory requirement that parties submit an MSA. So myself included, Sanderson firm, I know others in the industry, all got on the horn with CMS and were like, again, this is stepping beyond the bounds of what you're allowed to do under the MSP Act and its regulations. This is going too far. And so, of course, they had to react when the industry reacted in that way. They held a webinar in February, and then they updated the reference guide. They completely updated the section with some very key changes. Now they're saying, okay, if they have not reviewed the MSA, that Medicare, it may, in their sole discretion, actually deem a non-submit MSA to be improper if it is shown that at the time that the MSA has been exhausted, that it was not appropriately funded or not appropriately administered. Now, so we need to understand what this new language says. And again, I want to also mention that Medicare said on their webinar in February that their stance on non-submit MSAs had not actually changed. And so what prompted them to now include this section in the reference guide, what CMS said was that they were asked by many industry stakeholders what their position was on non-submit MSAs. So they felt compelled to kind of say, well, if we haven't reviewed the MSA, we can't know it protects our interest. but that they'd always taken that position. So nothing really had changed. But when Medicare released this language, it did send shockwaves through the industry to the point where, some work comp insurance payers stopped submitting MSAs, doing non-submit MSAs, stopped doing non-submit MSAs and went back to submitting because they were now afraid that their non-submit MSA would not be recognized. But that's not what CMS was trying to do, or at least that's not what they said they were trying to do. They said that, basically that if they were to find an MSA to be non-sufficient, they would afford the full due process right of appeal to primary payers. And also, I want everyone to keep this in mind that really, first of all, Medicare's never challenged a non-submit MSA to our knowledge, especially not here at Sanderson Firm or in my prior history and working with them that I'm aware of. But also, I want to make everyone aware that really two things have to happen before this would ever even go down. First of all, the claimant has to entirely exhaust their MSA. I think we all know if you work with work comp claims that generally treatment slows down post-settlement, after, the settlement is closed, usually injured workers treat less. So the likelihood of exhaustion is much smaller. And then number two, then Medicare has to be billed for something that they now find to be a part of the work comp injury, and that they are now saying, well, okay, we're not going to pay for this treatment because basically the MSA should be paying for it. So haven't seen that arise, and then at that point, the parties would have due process rights to go through the appeals process and to petition Medicare to now reinstate the Medicare beneficiaries' benefits by proving that the non-submit MSA was legitimate. Now, this is all theoretical, and we've talked with CMS about this. There would be the appeal process, but Medicare has never challenged an MSA. And I do believe that, so long as parties can show that the MSA was legitimate and reasonably protected Medicare's interest, that it will be recognized in the future. So we're now 2 years removed from this reference guide update I was just talking about. What are we seeing? Again, we've seen no known challenges to non-submit MSAs, right? If you've got a non-submit MSA situation, the best thing to do is make sure you have full indemnification on that non-submit MSA. That's something that we offer here at Sanderson Firm. We indemnify our non-submit MSAs for all parties to the settlement. We are making sure that our files are prepped and ready. If Medicare were to ever challenge one of our MSAs, Deanna and her clinical team have the most intense clinical notes as to how and why we allocated for everything. There's an evidence-based reason or a legal reason behind how we allocate and everything that we do. And in fact, we've had, steady requests for our non-submit indemnified MSA. And so 2 years later, we at Sanderson Firm are seeing that Medicare's little scare tactic there with non-submit MSAs, frankly, didn't work. We're seeing as a whole, some of those work comp payers that used to submit MSAs to CMS actually go now to non-submit. And so we're seeing that this is going to continue to trend in that direction. And this is an industry-wide trend, not just at Sanderson Firm. And also right now, CMS's current initiative has since shifted its focus to the potential reporting requirement of work comp MSAs via Section 111 reporting. So there's a potential upcoming MSA reporting requirement. Like I was just saying, last year, Medicare hosted a webinar talking about how they were thinking about, wanted to let the industry know of their intent to potentially have work comp payers report Medicare set-asides through the Section 111 reporting process in the future so that they could get this data and know about both submitted and non-submit MSAs. So we were on this webinar. I know Brendan and we attended, and we asked some questions of CMS because we were wondering why too. And one of the questions I actually typed into the chat was, why does CMS need submitted MSAs also reported in the Section 111 when Medicare's already reviewed the MSA? It didn't seem to make sense to me that they needed to know about it again for the second time. And they basically said it was a lack of communication issue. So basically what happens is Medicare approves an MSA, parties might go off and settle the case, but until a copy of the finalized settlement documents is sent to Medicare, they don't know if the parties funded the MSA and that if they actually used the CMS approved MSA. So they were saying it was kind of a communication issue, and that's why they want to know about it so that they can properly coordinate benefits. They did reference the CMS submission process of MSAs again as voluntary. They did acknowledge they'd want to know about non-submit and submitted MSAs, and we do not believe that this is an attempted, attack on non-submit MSAs. So regardless of whether it was submitted to Medicare or not, this would be a scenario where Medicare might potentially want to see the MSAs. They want to know how to coordinate benefits. And again, they did keep referencing it as potential. They talked about timelines, which I believe I'm going to give over here to Brendan to talk about, but these are all not set in stone, right? We want to make sure everyone's clear. Medicare was very much like, this is what we're thinking about doing, but we're not so sure yet. Don't hold us to all of this. And I think even the fields that they want to see, that, this is going to take, Brendan. I mean, companies have been doing, responsible reporting entities have been doing Section 111 reporting since 2010. They have their systems, they've got certain fields ready and built out. This will require some build out of some additional fields and some technical changes both on RRE's end as well as CMS's end. And I don't see this being so simple as being released in the next year or two, but that's just my opinion. I don't know what you think. And sorry, I'm getting in front of myself about it, but as you can tell, I think I understand CMS's intent. I just don't think it's that easily implemented that quickly.
No, I agree, and I think it's going to be tough on CMS's end. It's going to be tough on the primary payers end, and this isn't finalized, but I as I get through this slide, I have just some recommendations or just questions on the information that CMS is collecting and essentially how to make it better. So here, let me sort of go through this slide. So currently, as of late last year, this is the information that Medicare is going to be requesting that RREs report when they're reporting this workers' compensation MSA involving a Medicare beneficiary. So what does CMS want to know? Obviously, CMS wants to know the MSA amount. That makes sense. CMS is going to want to know the MSA period. So, right, when you prepare an MSA, you calculate it and prepare it based off of the individual's life expectancy. So if you prepare an MSA, their life expectancy is 13 years. You calculate out the costs per year. You multiply it by 13, and that's how you get your final MSA number, right? So CMS is going to know the projected period of coverage in years. CMS is also going to want to know whether this MSA is being funded via one lump sum or whether it's being annuitized over time with this small initial deposit and each year's annual amount. So with that, if it's funded via annuity, as you can see here, CMS is going to want to know the initial deposit amount. They're also going to want to know the annual anniversary deposit amount as well. Interestingly, CMS is also going to want to know the case control number. So how do you get a case control number? Well, you get a case control number if you submit that allocation to CMS for review and approval. And as you'll see here, this case control number is not a required field. So it's an interesting little filter that CMS put in here. So presumably if an RRE reports an MSA to Medicare and there's no case control number, CMS can, I guess, sensibly apply a filter to look, there's no case control number, so they probably did not submit this allocation to CMS. And then lastly, CMS is going to want to know if it's being professionally administered, who is the entity that's professionally administering the MSA itself. So, but we kind of get through all of these items that CMS is requesting, and I find it interesting that CMS doesn't want to know more information about the conditions, like which condition is accepted, which conditions are denied. We'll use me as an example, right? Hypothetically. So imagine I'm a Medicare beneficiary, I have a workers' compensation claim, it's fully compensable, and I injure my arm. So let's say post-settlement, everything works great, it's settled, I got this MSA for my arm. Post-settlement, maybe I'm involved in a car accident, and in this car accident, completely unrelated to the work comp claim, I break my foot, right? So I go to the doctor, and maybe it's serious, right? Like maybe I need surgery, right? So I go to the hospital, right? And I get surgery, and the bill comes to me, and I say, okay, well, this is not related to my work comp claim. It's not for my arm, so I'm not going to use my MSA funds for this. That would be inappropriate, right? So let's say I say, okay, hospital bill Medicare. Medicare is billed for that service. There's nowhere in here that says this MSA that Brendan got was for his arm. So I mean, is Medicare going to see that bill and they're just not going to know? They're just going to say, okay, well, we're not going to pay for your foot surgery because we think it's something that was in the MSA. Like, is that a possibility? I'm not sure. I still have questions about this. There appears to be gaps. Um, Interestingly, if you actually proceed to the next slide here, apparently there is going to be some mechanism for CMS to figure this out. So you'll see the first bullet point here, which is pulled from Medicare's original town hall webinar where they were explaining this. Medicare said, quote, "A WCMSA record will be posted to the common working file preventing payment of medical services related to injuries described by the diagnosis code." But where is CMS collecting this diagnosis code? I can understand on files where you have the MSA and you have a case control number because the file was submitted to CMS. So CMS has a copy of the MSA, but I don't know. What if you have a non-submit MSA? I mean, how is CMS going to know what is and isn't related and when Medicare should be making payment? A little confusing to me. Or there's a gap there. Maybe I'm missing something. I don't know, but it seems like there should be an additional field there. So that's interesting. Other things to note here. So notification of the WCMSA will be sent to the beneficiary, indicating the process for attestation and exhaustion, right? So in this potential new world where all MSAs, either submitted or non-submitted, are reported to CMS, these beneficiaries are going to be receiving letters. So now not only is the beneficiary going to be receiving conditional payment letters on lien amounts, now they're going to be receiving letters on their MSA. And good, bad, I'm not sure. Maybe that results in some confusion, but there's just going to be more correspondence on these MSP related files. Additionally, in process WC MSAs, those where settlement has not been reported, will be updated to reflect the voluntary WCMSA has been completed. And lastly, of course, of note, these changes only apply to workers' compensation claims. So there's not going to be, at least now, there's not going to be a requirement to report a liability MSA or a no-fault MSA. This is only for Medicare beneficiaries and workers' compensation settlements. So, as Heather alluded to earlier, CMS came out with rough timelines. These are not set in stone. We're not sure if CMS will stick with these, but according to CMS, there will be an updated file layout in the Section 111 reporting portal in early 2024. Testing will be available apparently in the fall of 2024, and this will be implemented in January of 2025. These are some pretty quick turnaround times. We'll kind of see how this plays out. Okay, so as we recap this, just overarching points to keep in mind. So one, so obviously, the reporting of MSAs is a component of Section 111 reporting. Section 111 reporting only applies to Medicare beneficiaries. So if you have an MSA and the claimant is not a Medicare beneficiary, then that MSA is not going to be reported to CMS through the Section 111 reporting process. This even applies to individuals who are reasonable expectation claimants, right? Because MSAs are appropriate for not only Medicare beneficiaries, but those who are reasonably expected to become Medicare beneficiaries within 30 months of the settlement date. So those who recently applied for SSDI or those who are 62 and a half. Even this subset of people, their MSAs are not going to be reported to CMS because those individuals are not Medicare beneficiaries. Secondly, submission of the work comp MSA remains voluntary, and the upcoming work comp MSA reporting requirement does not represent a policy shift with respect to the validity of non-submit evidence-based MSAs. CMS referenced the WCMSA submission process as voluntary several times throughout their webinar a few months back when they were sort of rolling out this or introducing this reporting program. Third, super important point here, potential reporting of MSAs is not a direct attack against non-submit / evidence-based MSAs. As Heather alluded to earlier, there's simply, at least according to CMS, there is an information gap. And even in cases where allocations are submitted to CMS, the loophole isn't necessarily closed. And post-settlement, even though parties may be submitting the allegation to CMS, the parties are not then later notifying that CMS that the claim actually did settle with the allocation amount. So this is just simply information gathering at this stage. And then lastly, also very, very, very important, this is not a current requirement. Don't need to do anything right now. If you have an MSA involving a Medicare beneficiary and a work comp claim, it's not currently reportable.
Okay, just briefly, just want to make sure everyone is aware that the current contractor, the WCRC, remains Capital Bridge. They were renewed in late 2023. They have been the current contractor since 2017. Typically, we see them change out contractors, but this is the first time they've elected to renew the contract with the existing contractor. This is a good thing the way we see it, because it's really going to allow us some consistency with the WCRC. Whether good nor bad, you know, we know generally what we're getting here. We don't anticipate any major changes. But you know, the statement of work noted that the WCRC is supposed to participate in certain number of presentations per year, but we haven't seen them do that. It would be nice for the WCRC to put on some kind of industry learning, but they have not yet done that. There is a provision in the contract where the current WCRC could be compelled to review as many as 1,000 liability MSAs per year. Again, we haven't seen any movement on the liability MSA front for a while, but technically per their contract, if Medicare was to move on LMSAs, which we'll see whether that happens, you know, then the contractor would have to review them. And again, there's no movement on LMSAs to date. Now we're going to turn it over to Deanna to talk about some cost containment strategies and some ideas she has for you all with regard to MSAs.
Yes. Hi, everyone. I wanted to take some time to talk about cost containment strategies and explain some of the techniques that we have implemented and in turn have had significant impact on the file's lifetime cost. At Sanderson Firm, we take a very conservative, consultative approach. We identify any high cost red flag areas that we see, anything from surgical intervention, medications, injections. One of the important processes that we follow is confirming that all the medical treatment records in the last 2 years are available. So we take a really deep dive into all of the prescription and payment histories, comparing with the medical records provided to see if there's anything missing. If there is, we then provide a request and see if that information is even available. And as we have seen, that one missing piece, that one missing medical record could completely change the trajectory of the claim and alter just the treatment. And I'm going to show some examples here in a minute. It could either be in that missing record. We don't know if it's a recommendation of treatment or maybe even a recommendation of treatment that has already been performed. Without that record, we just don't know. And when we have taken this approach, it really has decreased the potential for developments and making sure we have all the records when we prepare the application. And it provides a more accurate treatment plan with having the full story in front of us. And reviewing those medical records for accuracy is the next process that we do. We, in those records, we see copy and paste the cookie cutter information from office note to office note. That's the same information. There's also misinformation in those documented medical records. And I have some examples here of some misdocumentation. The first one, the patient underwent a left toe amputation of 4 toes 1 month ago. Prior surgical history includes a left knee amputation last year. Well, you can't amputate something that's already been amputated. Another one that I saw, a patient has severe pain complaints of the left arm, head, ear, and is increasingly aggressive, but can be out with a cup of coffee or can be put down with a cup of coffee. And my favorite one, the patient has had an allergic reaction to contrast, strawberries, shrimps, and also 2 of her children. So these, although they're inaccurate, you know, we have to make sure that the inaccurate information, that these are funny, but there are information there that is pertinent to the claim, pertinent to the injury, to make sure that things are, that line up and that makes sense to the medical records. So in confirming any miss or unsupported documentation, our clients do not typically receive surprise treatments in their MSA products. We understand that these types of surprises are not the good surprises, and we strive to communicate any of those recognized issues that we identified. And also the identifying of the high cost treatments. So we provide a medical mitigation service. And with this consultative approach, if the red flags are identified, we can alert the client and provide a primary treating physician record. or letter. When we provide that letter to the physician, we are trying to clarify any misinformation or inaccuracy in the records, any issues of high cost treatments, and possible treatment alternatives that may be a possibility for that claim. On the next slide, this is one of the examples. The physician recommended very vaguely an SCS and the spinal cord stimulator. And as you all know, based on this one treatment, this one statement, this one could have been missing medical record, treatment has significantly increased. So because of that statement, future care is now going to include the psychological evaluation, an SCS trial, the implementation, the permanent placement in any revisions based on the life expectancy, as well as intermittent reprogramming of the SCS. So this one statement was not a cheap statement, even though it was vague. So the client requested a medical mitigation service. We were able to provide that letter to the doctor. This, as you can see, this recommendation was close to the 2-year timeframe, but was not within that in 2021. But we were able to receive clarification from this physician and confirming that this was no longer an accurate treatment plan for this claimant. And the SCS and all this treatment was removed, seeing that we saved over $165,000 for having a realistic treatment plan. Here's another success example where the cookie cutter medications that I was talking about earlier. So in those medical records where they have the current medication section, sometimes they have those medications listed service after service over and over again where they haven't been changed. We have, the support that they haven't been filled, but they're still being listed. There's been no new prescriptions paid. We are able to provide medical mitigation service on this claim as well, presenting the physician with a letter. And he confirmed that these treatments were for post-operative period only. They had been discontinued. The claimant was no longer treating on a monthly basis. The medications were discontinued, as well as that left ankle post-operative brace. And here we saved over $70,000 just by receiving that clarification. Within a matter of weeks, we were able to submit, and CMS agreed with the removal of those medications and brace that they were during that post-operative period. So in performing these consultative approaches, in each of our files, our clients are receiving more of a realistic projection and not just looking at the claim as a whole, but also the individually services that are being provided to us. And the other thing that I wanted to talk about was CMS trending with physician office CPT codes. We all know those famous 99213s, 99214s, and the biggest difference between them is the 99213 only goes up to 29 minutes, where the extended visit is the 99214 for anything over that up to 39 visits. And in looking at this, there's also some additional things that go into these, with not just the time frames, but comorbid conditions, how many conditions are being treated, what's the complexity of the injury. Typically, a yearly office visit and surgery visits are allocated for the 99214. But if you think about it, in reality, the 99214 is for the higher visits on a yearly basis. It's going to take more time to review information that the claimant is either complaining on or things that have happened. Coming up with a treatment plan takes a little bit more time than if the claimant is seeing that physician every 2 to 3 months. If that claimant has a long life expectancy, the change in one of these codes could result in a significant difference. On that last slide, it showed a $6,000 difference just between that 99213 and 99214 codes. So this approach really supports looking at the claim as a whole instead of just the individual physician visits or doctor's visits with that one record, we may say.
Thanks, Deanna. And I love those examples, by the way, super funny. So here, guys, on the webinar, I recognize that it's about 2:24 here, so I'm going to move a little bit quickly through some of these slides. Okay, so just so that we can get to at least one question. Okay, so switching topics here. So $0 MSA. So what is a $0 MSA? It's exactly what it sounds like. That's a Medicare set aside where there is no treatment provided in the actual allocation itself. And that can happen for 2 reasons, really. Either one, you've got a legal zero where, let's say there's a statute of limitations defense and the underlying claimant waited too long to file their work comp claim. Maybe the claim was otherwise compensable. Because they waited too long, they are ineligible for benefits, right? So a legal $0 MSA would be appropriate in that case. Other cases, more common cases, are medical zero MSAs, where based on the medical records, you know, $0 MSA is not appropriate because the person has, fully received all treatment and doesn't need any further care.
Sorry
you.
about this, Brendan. I'm jumping ahead, but I think what we're gonna do in the interest of time here is just talk about like what we're seeing as far as the difficulty of submitting $0 MSAs to CMS, right? So we get this question a lot, the desire for a zero MSA, but it can be difficult to get CMS to approve them. They're going to want to see the last 2 years of treatment records. So if the claim was denied and no payments were made, so we've seen some of our clients struggle to provide these last 2 years of treatments, or if there's not been any medical treatment in the last 6 months. So Medicare may require statements from the treating providers to determine the date of the last treatment and if there were any future treatment recommendations. This can further lengthen the CMS submission process and will also increase the amount of development letters that a submitter will receive. So if you're looking to actually submit a $0 MSA to CMS, you definitely want to have a clear and unequivocal statement from the treating physician that the person will no longer require any future medical care related to the injury. That can be a difficult opinion to obtain, but really important that you have that. Definitely, you want to have underlying medical records with consistency. Otherwise, Medicare might not accept the zero. If you've got a denied situation, I believe that having a court order issued after hearing on the merits will certainly help. But again, as I talked about earlier, it's not a fail-safe in having a court order, as at times Medicare does not recognize court orders. So if you have any questions on zero MSAs, we're happy to help. You certainly want to make sure you have a great package to submit if you're going to try and get CMS review of a zero. We don't believe that the CMS submission process was truly designed for review of zeros, because really that should be within the purview of your claim as to whether a zero is appropriate or not. Just be careful on those types. But I just want to briefly mention to you all that Sanderson Firm provides over 7 types of Medicare set-asides to suit our clients' different risk tolerances and settlement objectives. All allocations receive a quality assurance review by our seasoned legal team. So there's a clinical and legal element to all of our MSAs. We're making sure that it's defensible and sound and the most reasonable allocation possible. And as Deanna was talking about earlier, we are consultative throughout that process to make sure that you're getting the most accurate MSA. All of our MSAs are overseen by attorneys before they are finalized to make sure that we have the most legally sound MSA. We have the most innovative MSA solutions in the industry. We are confident of that. Our unmatched indemnified Medicare set-aside program, our IMSA program, and our EMSA program are unmatched in the industry. And we are a recognized legal authority on MSP compliance, and we make sure that our clients get their optimal outcomes. All right, Lisa, I'm going to let you just briefly cover the rest of our services, and then we'll hop into Q&A for a minute or two that we have left.
Yeah, thank you, Heather. So like you mentioned before, the different Medicare set-aside services, from a traditional work comp MSA to the IMSA, legal compromise, evidence-based MSAs, as well as medical cost projections. Deanna spoke on the medical mitigation. We also provide services for lien resolution as it pertains to Medicare, Medicare Advantage plans, Part D and healthcare liens, as well as Medicaid. We also offer Section 111 reporting and guidance and audits with your Section 111, as well as a SSN and date of birth research service. Other services, MSP legal advice, settlement agreement review, mass tort class action, MSP opinion letters. We do get rated ages on all of our files, so we do have that service to offer, as well as benefits coordination, medical mitigation, and Medicare eligibility verification, as well as SSDI checks. And we'll go ahead real quick, Heather. The first question that we have is, does CMS seem to prefer MTUS ACOM over ODG? Is this based on jurisdiction?
I'd be curious, Deanna or Brendan, if you could chime in there on what we're seeing more specifically. I believe ODG is the preferred, but defer to you.
Yeah, that's a really good question, Jill. So In the WCMSA reference guide itself, it says, CMS will reference evidence-based guidelines, and it says, I think the wording is, as an example, Milliman and ODG, and Milliman and OGD are similar, but ODG is referenced in the guidance. ACOM is not, but I think CMS used the term as an example to mean that, other, reference materials can be used. So ACOM is still fine. I haven't noticed a preference one way or the other.
And we take the position that, if a particular work comp jurisdiction has adopted one of the evidence-based guidelines as part of their work comp guidelines, that's the guideline that should be appropriately applied.
All right. So if a non-submit claimant has exhausted their MSA with medical care, but has no funds in the MSA, regardless, is the belief that Medicare will pay for care and then just file a claim direct against the claimant.
I'm not sure exactly if I'm understanding the question, but I think what I'm hearing is an MSA has been exhausted. That was a non-submit. What happens if Medicare now denies payment? Would they file a direct action against the beneficiary? No, they wouldn't file a direct action. There would be potentially a denial of benefits, which would afford the full due process and appeal process for parties to go through to petition Medicare to reinstate that person's Medicare benefits.
And that was the last question, Heather.
Okay, great. Well, thank you everyone for attending today and for staying on with us a minute or two after the hour. We really hope that today's presentation was helpful. Stay tuned for more webinars throughout the year. There certainly will be more. Please do fill out the survey. As Lisa mentioned, we appreciate your feedback and your time today. Wishing you all a great week. Thanks so much. Bye-bye.
Bye, everyone.